Very good. All right, so welcome everyone this morning to our part of our breakfast series, which obviously we're doing a little bit differently today with us all working remotely at the moment and putting in place all our physical distancing that we're doing as part of all of our contribution towards flattening the curve on COVID-19. We've got Andrew Bland talking this morning, and as you may be aware, we've changed the topic and really looking to talk more about COVID-19 and what some of the things that you can be doing and what options you can have in place for your workplace. So thank you very much, Andrew, for making the time to talk with us all this morning, and I'll hand over to you.
Thanks, Linda. Hi, everybody. For the purpose of this live session, you've got the capacity to ask questions just as we would in a face-to-face session. So Linda's going to control that. So if you have any questions, just like those who've been to my live sessions before, I like to sort of have questions come as we go, as opposed to waiting to the end. So please sort of type them in, and Linda will interrupt me when we get a question, and we can sort of discuss that. So as per a live, a face-to-face session, let's do it as much in terms of a conversation and a discussion as opposed to me just on a PowerPoint presentation. So yes, as Linda said, we're going to concentrate on the COVID-19 stuff, both from the perspective of what you need to do in terms of the self-isolating for employees and different scenarios. We'll also talk about the obvious impact that's occurred in the last week in terms of businesses and shutdowns and different options that you have as an employer in terms of dealing with your employees and what to do, given this is, hopefully, and everybody's talking about a temporary situation. So we'll go through that. Originally, this talk was supposed to be on annualised salaries, which was a big topic and something that came in on the 1st of March. That seems like a distant thing now. And so we probably won't get time to do that, but talk about that. If we do, I've put a couple of slides in and we can at the end. It's still a big issue, but I think it's in terms of priorities down the list. So let's get started. So in terms of
Andrew, you're just breaking up a little bit. I just might ask people if you could all turn off your video, please, just to help with the streaming would be great. Thank you. We've lost you, Andrew.
Is that better?
Fantastic, thank you.
All right, so in terms of options for employers, we'll talk about, obviously, if you work from home, and that works, but there's obviously some businesses, whether it be retail or manufacturing, where you won't be able to do that. And so we'll talk about situations in terms of self-isolating and unwell employees, standing down employees, options around redundancy, and then, as I said, if we have time, we'll talk about the salary provisions. All right, so from the 21st of March, and things are moving very, very quickly. And so even from doing this presentation and preparing it a couple of days ago, things have moved on. And so, but either way, from Monday, as we all know, certain facilities are now stopped, including clubs, gyms, cinemas, churches, cafes, restaurants, etc. That's not an exclusive list, but that's an example of what is going on. And employers in those industries have pretty much needed to shut down. I mean, if you're a cafe, obviously you can do the takeaway thing, and restaurants. But other than that, some businesses have had to shut down completely, and others are running on a skeleton staff. And as I've said there, even if your business isn't subject to those restrictions, it's still, as we all know, having a significant impact. So the question is, what do you do with your employees in this situation? So yeah, I've put on this slide a number of different things that you can look at as employers in terms of of how you deal with it. So let's just go through each one, and we can sort of explore those in a little bit more detail. So the first one I have there is the employee can opt to take paid or unpaid leave. Now, before I get to that, I'll just tell you a little bit about the stand-down provisions and how they work, because whilst that's fourth on the list and a little bit of a last resort, it is something that you need to bear in mind in terms of how you go about talking to your employees. So the stand-down is covered by Section 524 of the Fair Work Act. And it essentially says that where, and I'm paraphrasing here, but where there's a stoppage of work and it's out of the employer's control, and there's no reasonable employees cannot be reasonably employed and used, then the stand-down provisions can apply. So what does that mean? The section of the Act was put in there to deal with things like bushfires, floods, earthquakes, cyclones, those sorts of things where there was a temporary stoppage of work. And obviously, you know, unfortunately, a lot of businesses in your region also had to deal with bushfires early in the year, and may well have implemented these things then. But the point is that it's supposed to be used for a temporary stoppage. And my view, and I guess most of my colleagues' views on this, is that COVID-19 will fit into this type of scenario. So the stand-down provisions can be used in this situation where there is a stoppage of work. I mean, it's clear that the part of the puzzle that the employer, it's out of the employer's control, that ticks that box. But then it gets down to, well, can they be reasonably employed? Can they be used? And that is going to be something that is different for each business. And you need to look at, even on a, you know, if you have departments or you have different areas of your business, it needs to be looked at in different ways. For example, if you're in retail, but you have a clerical side or even a manufacturing side, then the manufacturing side may be, and sort of leaving aside the social distancing stuff for the moment, but even on a in a scenario such as that, the retail may be shut down because no one's going to the shops, but the manufacturing may still be able to work, right? So it's not about shutting the whole business down. You can look at different parts of your business and shut it down from there. So that's sort of a basic explanation of the stand-down provisions, which in our view will be available to businesses that fit that criteria. Certainly, as I say, the COVID-19 ticks the box that it's out of the employer's control. So then it comes down to, well, can the employees be reasonably used or not? Right.
So Andrew, if an employer was to move forward around with a stand-down option, how would they, was that about putting that in writing to their employees with what might be a current understanding of what the end date would be? How would they best go about doing that?
Okay, so the stand down, we'll come back to that, but I'll answer that now whilst it's fresh in my mind. So yes, it has to be in writing. It has to indicate an end date. Now that end date, you can put in the letter that the end date will be reviewed and changed. So for example, you may say, okay, we're standing down you for 2 weeks, and then we're going to review it every 2 weeks from there. We will, let you know if things improve, and obviously you'll be, invited to return to work once things improve. But you do need to put you need to put a date on it, but the caveat is that it can be subject to review, and you should say that in the letter as well. So you're essentially saying you're standing down. The stand down provisions mean it's unpaid leave. Now I'll get to the sort of the nuances of all that later, but that's essentially what you need to say in the letter. That it's unpaid leave, that it's a temporary situation until X date, and we will continue to review it there. I mean, all the scientific advice talks about sort of a minimum of, a couple of months from what I can understand. But either way, I think it's be conservative with your review date if you go down that road. Now, I emphasize that this is sort of a last resort type option for you, and not every situation you're going to be able to fit into a stand down. You can't just stand down all your staff just because there's been a downturn in business, right? You need to look at, well, what staff can be reasonably used and what staff cannot. But before we get to that point, I want to go through the other options because they're ones that you should, in my view, explore. But there are some sort of, again, nuance around how you go about doing that. So going back to the first bullet point, employees have to take paid or unpaid leave. So that's something that you can go to the employees and say before they're stood down and say, look, we're looking at a number of options here, but one of them is for you to take your annual leave. And so people may, that can be offered to them and they can take that. Now, you don't have to offer it, but as a way of keeping the employees in income, and from the employer's perspective, if you're reducing the annual leave balance, which is always a good thing, but it's kind of a bit of a win-win for employers, assuming that you can afford to pay it. And I'll get to some situations where you may not be able to afford to pay it and what you can do in those circumstances. That's a little bit more complicated, but we can also discuss that. Or you can just say, look, we're going to have to put you on unpaid leave, but that's sort of, you can do that even where there is a shutdown. Even where there is not a shutdown, you can offer that that option of unpaid leave. So that's one option, and again, that might be something that that is able to be done from the employer's perspective, from a financial perspective, depending on how much reserves you have, and certainly from the employee's perspective, if they've got some annual leave to push them through, or long service leave, they can access that. Another option might be to say, well, look, I'll take half of my annual leave and sort of spread it out over, so 50% of it of my hours in annual leave, and so effectively spreading it out over a longer period, but taking it in 50% increments. So instead of getting all of your, essentially you're spreading 1 week's annual leave over 2 weeks or something like that. So they're all options that you can consider. Another option is, now that obviously needs to be agreed between the two of them. I mean, you can't make someone take annual leave unless there are, it's the same situation as where there wouldn't be a downturn. You can't make them take annual leave unless they've got excess annual leave over those provisions in awards or in your own policies. And so, for example, someone that's got a couple of months annual leave, you can say to them, well, you need to take your annual leave to get it down to that 8 weeks, which is referred to in the award. Another option there, number 2 there, negotiating reduced hours. Now that's one that, for those of you that were around during the GFC 12 years ago, 11 years ago, that was one that was well used, and I think one that was Australians were early adopters of, and other countries have followed then and also are looking to follow now. And so what that is basically saying, well, look, you're a full-time employee. Why don't you, there is work for you to do, but not on a full-time basis. We've only got 3 days work for you, for example, instead of 5. And so in those situations, you can say to invite the employee to agree to a reduction in hours. And so, and also on the same sort of theory, a reduction in pay. So it may be, look, we have full work for you, a full-time job, but we just can't afford to pay you what we're paying you. And so we're asking you for an interim period, instead of you earning $100,000 a year, we can only pay you 70. Will you agree to that? Now, I stress in these sort of situations, you cannot unilaterally do that, either the hours or the reduction in salary. It needs to be by agreement. between the employee and the employer. And so what you would do as a strategy is go to them and say, look, we've got work. We're not going to stand you down, but we don't have work for a full-time role. We've only got work for a part-time role. And so would you agree to taking, to earning 60% of your salary, for example, instead of 100%? And you should, if they agree to that, it should be put in writing. So there should be a cover the agreement of the hours.
Andrew, we just lost you for
between the parties.
Andrew, we just lost you for a moment there. So you were just talking about putting that agreement in writing.
Yeah. So putting the agreement in writing, it just needs to be reduced to writing. It doesn't have to be a war and peace type document, but it just needs to be something that basically covers the fact that both parties are agreeing to the reduction, that it's a temporary situation, that once things pick up again, similar to what I talked about briefly with the Standdown stuff, that once things pick up again, then we will constantly review it. And the aim is for you to be returned to your full-time duties as soon as possible. And that's the understanding. And, you can even, there's no requirement to do this, but you can do things like, look, if we do need to make you redundant down the road, if things don't improve, you'll be paid your redundancy at your full-time salary, not your part-time salary. Should you choose to take annual leave, we'll pay it at the full-time, not the part-time salary. So that sort of covers off, situations where things change and they're not, the employee isn't suffering from the temporary agreement to reduce the hours or to reduce the salary. So that's another thing that, those are the sorts of things that I would recommend that you do in situations where you do have work available, just not enough work as there was before. Again, the employee doesn't have to agree to it, but it's the sort of thing that you say, okay, well, look, this is the situation. The alternatives, and you're free to discuss the alternatives. The alternative is, look, we may need to look at redundancy, where you lose your job. We may need to look at Standdown, where you're not getting paid. So these, please have a think about it and let us know whether you would agree to that. And, it's a sort of situation where you might have 10 people in your team doing the same role, and you really only have room for, 5 of them. So rather than standing 5 down, which you might be entitled to do if everything else, is aligned, going to the employees as a group and saying, look, there's a couple of options here. One is that everybody agrees to, in that scenario, take a 50% reduction on a temporary basis. So you all earn 50%. Otherwise, if we can't get some agreement on that, we're going to have to look at other options. And one of them is going to be, we're going to have to stand 5 of you down because we've only got enough work for 5 people. And so if that is the case, then, the employees can kind of decide amongst themselves whether they agree to that. And if some people don't, well, you go to a situation where you have to sort of use the Standdown. So let's talk about the Standdown in a little bit more detail. And in line of that, I'll just mention quickly the ex gratia payments. Some of my clients have come to me and said, well, can I make payments to them to sort of try and see them through? I've got a bit of extra money. And, for those that can't afford and don't have any annual leave or something like that, or as a combination, we'll pay you 50% of your salary as an ex gratia payment. Certainly no need for you to do this. It's just another option. 50% of your income as a ex gratia, and you can access 50% of your annual leave. It's just another way of trying to help the employees through this, because I think everybody's on board with the fact that, we all kind of in this together, and employers that I'm speaking to are certainly very cognizant of the fact that, they've got a business to try and save, but they also want to try and help out the employees as much as they can. All right, so then we get to a stand down, and again, I sort of explored this.
Sorry, Andrew, I was just going to mention that
Yeah.
we're also seeing clients who are allowing people to go into a negative leave balance.
Yep.
And so they might be allowing, for example, someone to go into, say, 5 or 10 days negative annual leave balance,
Yeah.
with the intention that obviously that would be made up when they return to work. And it's also been done on the understanding that if they were to leave, that it's actually understood that, you know, from a business perspective, they're actually not going to get that money back effectively. So they're doing on a, I guess, a goodwill basis.
Yeah, so, I mean, you're open to do that just as you would be, you know, in a time less troubled than this. You can always sort of agree or, you know, allow employees to go into negative leave. The obvious risks are the ones that you've pointed out there, which is that if they do leave or they're made redundant or whatever, then you won't get that money back. But yes, there's nothing to stop you doing that if that's something that you want to do. In some ways, the special leave, if you're going to do that, you may as well pay them just special leave instead. But you know, either way, you can certainly pay them or allow them to access those leave balances regardless. I mean, people have asked me, and I've got it down the bottom there because I'll mention it now, just in terms of options and leave. Can employers pay sick leave? My view on that is that you should be very, very careful about whether you do that or not. And I'm sort of advising against allowing people to take sick leave. Obviously, if they have a medical certificate to say so, then yes, of course. But sort of doing a deal as such with the employee where they access their sick leave is fraught with danger, and so I'd recommend against that. Now, obviously, you know, some employees will work out that a good way around all this is to, before they're stood down, go down on stress leave and or something like that, and you know, access their sick leave that way. And you know, again, just like in the good times, there's nothing really you can do about questionable claims such as that. But you know, I certainly wouldn't be doing a deal with employees to access their sick leave in the absence of medical evidence. So stand down, just going through that again. So that's a situation where employees cannot be reasonably used. So that can apply to a complete shutdown of the business, but it can also apply to partial shutdowns. Now, it's important in that letter that I discussed that that it's also mentioned in there that the shutdown is due to the coronavirus and not due to a downturn in the economy, because you need to be able to connect the incident that was out of the employer's control to the employer's right to use his shutdown clause. And so in terms of your letter, you just say, due to the COVID-19 situation, we are suffering, you know, there's been stoppages of work. The employer is suffering economically as a result of that, and, you know, simply does not have enough work for you to do and for you to be reasonably used. And therefore, and I'm paraphrasing, you'll need to sort of make sure that you're writing the letter in the correct way. But, you know, these are the sorts of things that you need to cover off, right? That they can't be reasonably used, and therefore we are standing you down. Stand downs mean that, as I said, that it is unpaid leave. So some people are asking me, well, can you access annual leave during a stand down? And the answer is no, you can't, because then you're not stood down. Now, that sounds like a semantic argument and it is a little bit, I suppose, and that's why I mentioned the option of paid leave prior to the stand down, because once they're on stand down, you don't have to provide them with leave. And indeed, if you do, then they're not actually on stand down. And so I think the way to do it is to say, look, if you want to access your annual leave prior to stand down, that's fine. Once you finish that leave, or once you don't want to take that leave anymore, because some employees may not want to use up all their leave, then you go into stand down. And so I guess you just need to get the order correct in respect.
Andrew, I've just had a question come through, or one of the questions come through has been that someone rang Fair Work and asked for some advice around stand down, and was told that because they work, it's an IT business, that because that's an industry not affected by coronavirus, that they weren't able to access stand down, even though they're a business that actually service retail, tourism clients and hospitality clients who have all closed down.
Yeah. Look, there are a number of different opinions out there about this, and I guess the thing I'd say about opinions in general, a lot of people have them, and that's fine. Fair Work, I'm not going to disparage them; they're doing the best they can, but I've had lots of people tell me, not just in this issue but other issues, ring Fair Work and getting different answers depending on who you talk to. I don't agree with the view that only some industries are affected by this. You do need to show that there is a stoppage of work, and that there are in particular departments, not even in particular departments, that employees cannot be reasonably used. But I don't think that the correct answer is that it only applies to industries that have been shut down by the government, for example. Like some people are saying, well, unless the government says that you can't open, you can't stand people down. I don't agree with that view. I think that a much wider range of businesses are affected, but they still need to be able to show that due to the virus, they have employees that can't be reasonably used. Now, that means that an employee that can do 3 days a week, that doesn't fall into a stand down provision, because they can be reasonably used, just not on a full-time basis. So it's got to be people that job is no longer required to be done. It's kind of similar to a redundancy, but it's due to the virus, and not just a downturn in the economy.
Can I, it's Kate here. Can I ask a quick question?
Yeah.
Andrew, I'm going to ask you to gaze into your crystal ball. There seem to be so many rapidly changing bits of legislation coming through. So the long service leave, what you have to do in terms of long service leave in New South Wales has changed. It's become a lot more flexible. Given stand down is a better option for employees, because it means they still have a job at the end when things improve, and they still accrue entitlements and all those sorts of things. Plus, it's a better thing for the employer, because they don't then have to pay out all these, entitlements and redundancy pay and notice and all those sorts of things. Do you think there may come a point fairly soon where businesses are allowed to stand employees down much more in line with kind of what you're saying, than it being following the letter of the law, and it's got to be absolutely 100% only if there's a stoppage of work? Can you see Fair Work legislating to loosen, loosen the requirements?
Well, it depends on whether you view the requirements that way. And, I guess what I'm saying is I don't.
You don't? Okay.
I don't think it's necessarily I'm looking, I think the way that section should be interpreted is the way I've said it, as opposed to, it's not so much the letter of the law. In my view, that is the law. That's the interpretation of the law. And so I don't think it's a question of Fair Work amending the legislation or loosening the interpretation. And again, people will follow the advice that they're given. But my view is, currently, and I'll let everyone know if the view changes, but it doesn't, it applies to businesses other than those where there's a government mandated shutdown. And so, it can apply to businesses that are negatively impacted as a result of their customers no longer providing them with work because, you know, they've been affected by the COVID-19 situation. So I don't know whether that answers the question, Kate, but it's kind of, I don't think there needs to be, in my view, a loosening of it or a relaxed interpretation, because to me, that's the interpretation. I should stress there's no case law on this.
Yeah.
So,
yeah.
you know, everybody's kind of got, as I say, their own opinion. We've at BlandsLaw given it a lot of thought and gone to and fro on this stand-down provisions, who applies, into, you know, what you can do, how that affects employees, et cetera, et cetera. And, you know, unfortunately, it's not something, you know, with a bushfire or an earthquake, it's very, very clear, and businesses usually will be able to will be affected or they won't. You know, if you can work from home, and I guess that might be the point with IT, is that you do have work for them to do at home. The question will be, do you have enough work for them to do, and why do you not have enough work for them to do? And my view is that you can say that it's more than just a downturn in business. It's directly due to an incident which was out of the employer's control. Now, that might be a view. I know I'm not alone in my view on this. And I also know that there are plenty of people that have a different view. And I guess that's not particularly, if you're asking for, well, look, you know, what is the universal view on this, or what is the correct view? I can tell you, I think my view is correct, but again, it doesn't surprise me that Fair Work has a different view, just as it doesn't surprise me that there's a whole bunch of people that believe the same thing I'm saying.
Great, thank you.
All right.
And Andrew, in terms of if someone is stood down with no pay, my understanding is that they're not, that during that time they actually still accrue entitlements, and they're actually still paid for public holidays. Is that?
Yeah, that's right. So all annual leave, sick leave continues to accumulate. So you, and the continuous service provisions, you know, like your continuous service continues, meaning that, you know, if you've had, just because you're not employed for 6 months doesn't mean that you lose the continuous service of the previous 5 years or whatever it might be. And as you say, Linda, annual leave and sick leave continues to accumulate regardless of the fact that that the employees aren't getting paid, because it's a temporary thing. So it's different to a situation where someone goes on a period of unpaid leave for whatever reason, because they're out of sick leave or whatever it might be. Then in that situation, outside of a stand down, you obviously wouldn't be accumulating leave. So yes, you continue to accumulate leave regardless of if you are on a stand down. And again, the difference between a stand down and a redundancy, and the advantage of a stand down for employers is that you know, you're keeping the staff, and you're keeping your options open, frankly, and you're not having to pay out redundancies where you might ordinarily have to do that. Now, where the situation becomes not temporary, for example, if you close a store and not on a temporary basis, but you say, I'm finishing up and we're closing down the business, and that's where the stand down provisions will fall away, and that's where you'll kick into redundancy. And that, you know, we've covered all that, and we don't really have time to go through what a redundancy is and all, and how you know, it's important to follow the process, just as I've mentioned in previous seminars, but that's where the redundancy will kick in. But again, from an employer's perspective, if you can fit into those stand down provisions, do that, in my view, over going down the redundancy, simply from a cash flow perspective for you, and for the employee, it keeps their job intact. Now, one thing I should say about stand down versus continuing to pay employees, you know, through reduction in hours and so on, is that where you've got business,
Andrew, you've just broken up again.
Can you hear me now?
I can hear you now. Yep.
Okay, great. Apologies for the internet. I guess it's just a lot of people streaming at the moment in my area. But Yeah, so I was talking about, what was I talking about? Can someone remind me?
Difference between Standdown and redundancy.
Oh, no, that's right. I went on to talk about the government assistance package. So the small business, businesses with less than $50 million turnover will be entitled to a credit on their withholding pay. So where you pay employees and part of your BAS, withholding tax is paid for your employees, then for the, you'll be entitled, it's a cap of 100 grand, but you'll be entitled to 6 months, you'll be entitled to credit your withholding pay. So if you pay withholding tax pay of say $10,000 a month, then you'll get a credit on that from next month, from your March BAS, which is paid in April, you'll get a credit on that. So what that means is if you've got employees on Standdown, then you're not paying them and therefore you don't get the benefit of that credit. Now, obviously it's not going to save businesses, but it is something to think about in terms of your options, because it is something that's, might make the difference, or might be part of making the difference to keeping your business afloat. So that's just something that you need to consider in terms of whether you exercise a Standdown if you can, as opposed to something else.
Andrew, from an employee perspective, if they're stood down, do they still have the right to go to Centrelink and get their payments, or does that affect that?
Yeah, it's a good question. And Linda and I were talking about this yesterday, and I did a bit of reading last night, and I still don't have a complete view on it. I mean, there's been discussion from government ministers and the Prime Minister himself about people being stood down, being entitled to access those benefits. But I don't know whether he's using stood down in the correct legal sense as opposed to, being terminated. And so there's a bit of kind of relaxed language, I suppose, from people that kind of aren't lawyers or aren't experts. And so the answer is I don't know, but once I do know for sure, I'll let you know, or I'll let Linda know, and she can pass it on to you guys. But at the moment, I actually just don't know the answer.
Yeah, and Andrew, I think it's that clarity too around what does it mean if you're on unpaid leave versus you're stood down, because the government websites talk about stand down, but they don't talk about being on unpaid leave and being able to access benefits if you're on unpaid leave. So we do need clarity around that. So we'll look to get that clarity and get that information out to people.
Yeah, I mean, it's important, because you want to be trying to do the best thing by your employees.
Sorry, Andrew, we've lost you again.
Try and put him. Can you hear me now?
Can hear you now.
Okay. So I've just gone on to another slide. We've only got 5 minutes left, and I just wanted to quickly touch on the big issue from a week ago, which is, still an issue, but just, I guess, is just less of a people trying to save their businesses as opposed to looking at their options around what they do with staff who are infected or potentially infected and what you do about it. So employers' obligations will depend on the reason for the self-isolation. Again, there's a lot of different views out there on this, and all I can say is we've given it a lot of thought, and this is the view that we have formed. So self-isolation, where you're not well, but you are required to quarantine, then you can access, my view is that the employer itself doesn't have to pay those employees, that is, wages for that period of time. So a situation where the government has said, you must be shut down. No, so someone returning from overseas, now this obviously is a short-term issue because no one's allowed to come into the country at the moment, but it was an issue a week ago. So employees that have come back from overseas and required to self-quarantine for 14 days, regardless of whether they are well or not. My view was that they could access their annual leave, but the employer didn't have to pay them out of their own pocket, but they were entitled to be paid. But they couldn't access their sick leave, personal leave, because they weren't sick. necessarily. They were just being required to self-quarantine. Self-isolation, voluntary as a precaution. So someone that comes to you and says, look, I'm not sure whether I have it, or I'm not even sure whether I've been in contact with someone, but I might have been. And so I want to self-isolate as a precaution. Again, they're not sick. And so my view is that you don't have to pay them personal leave, but they can access their annual leave should they choose to do so, and an employer doesn't have to pay them. Now, again, I know that someone pointed out to me the Ombudsman's site, at least from a week ago, had a slightly different view, but I read that and even that was ambiguous as to whether they should be, I think they said they should be paid, but it didn't necessarily say whether the employer needed to pay them outside of leave. But in any event, I know that there are other views where employers should be paying people to self-isolate. And again, I should say this is all in situations where employees can't work from home. And where they can, obviously, that's what you do. And again, we've moved on to the point where I think most employees that can work from home are now working from home. But it's covering situations where you can't work from home, and we all know what industries they are, and there's plenty of them, and that's the ones we're sort of dealing with here. But again, I know that there are other views that say, well, the employer should pay them, and I know that, big companies such as Telstra and others have come out and said, we will pay for them. I'm looking at it from the perspective of a small business or a medium-sized business where, in my view, why should the employer, why should the employee be out of pocket? Yes, totally understand that. But why should the employer be out of pocket for someone that can't work as a result of, something that the government has mandated? My own personal view is the government should be picking up the tab for that. But in any event, that the employer should not, outside of allowing them to take annual leave. And then self-isolation where they are unwell or they're caring for someone who is unwell. I think that is a situation, obviously, where personal leave can be accessed and should be accessed. So someone who has a family member that has been quarantined and they need to look after them, then I think that's a situation where carers leave kicks in, and you can access the personal carers leave. This next slide is one that we've kind of dealt with already in terms of your options, so I won't go through that, but that gives you, I can see that the internet connection's unstable again, but hopefully you can hear me. That I've just have a read of that slide because it sets out what 524 says. So an employee can only be stood down without pay if they cannot be usefully employed because of a stoppage of work for any cause which the employer cannot reasonably be held responsible. So that last part of it, the employer cannot reasonably be held responsible, I think the COVID-19 thing fits squarely into that. The arguable bit comes around the stoppage of work, and also obviously where an employee cannot be usefully employed. So that's the question that you need to answer for yourselves in terms of the option of a stand down is, can they be usefully employed or can they not? And if they can't, then you do have the option, in my view, of standing them down, regardless of whether it's an industry that the government has mandated must close. Linda, we're sort of at the 8:45 mark, 45 minutes. I didn't get onto the annualised salary, but I think, we could spend 3 hours talking about this stuff because there's so much that is unclear or, from an employer's perspective. But I think hopefully this has given you a bit of a snapshot into your options, which is really, I think that's what employers want at the moment is options for what they can do, what's open for them to do. But really, I think the starting point is talking to your employees and saying, look, where we can take your leave before we stand you down, where we can reduce your hours so that less people are going to be unpaid. They're the options you should consider first. But if you have to get to a stand down and redundancy, then hopefully you've got a better idea of your options there and your obligations.
Thank you very much, Andrew. And we'd encourage anyone who's got any queries or concerns, please feel free to approach ourselves or Andrew Bland at BlandsLaw. We've been working with clients on these issues for the last couple of weeks, and we've got clients using all of those different options. So people looking to take a reduction in pay where they're paid well above the award, people who are looking to go to split shifts, to go to different shifts as part of separating people and actually working fewer hours. We've got others that have moved to stand down. We've got people who are taking leave without pay, and we've got others who unfortunately have moved to redundancy because of, I guess, what this has meant in terms of the long-term viability of the business. So if you need any assistance with any of that, the team at Total HRM is ready to help. And we continue to work with Andrew and his team at BlandsLaw to work through any particular tricky issues that we're facing. So I just want to thank you very much, Andrew, for your time this morning. It is an evolving discussion, and we'll continue to provide information to people as we become aware and where clarity is provided, particularly when it's provided by the government as to access to benefits and those kind of things. We'll continue to share that with you all. So thank you very much for taking the time to talk with us this morning, and particularly thank you to you, Andrew, for putting together the presentation and talking with us this morning about this complex issue.
Thanks, Linda. Thanks, everyone.